Good evening, and welcome to this week's Black Mental Health is Black Health. I'm your host, Bronwyn, Miss B, the Black Therapist. And today we have an exciting guest, and you know how we do it. My guests will introduce themselves, but first we must take those three deep cleansing breaths. A time to decompress from the day, just that woosah moment. So let's do it. Breathe in, 2, 3, 4. Out, 2, 3, 4. In, 2, 3, 4. Out, 2, 3, 4. One more. In, 2, 3, 4. Out, 2, 3, 4. Just that woosah moment, good day or bad day, we can all use just that woosah. Well, today we have a very exciting guest, Nakia Bryant, and she gets to introduce herself. So, Nakia, thanks for joining us this evening, and tell us who you are, what you do, and something cool about yourself.
Well, good evening, Miss B, and thank you so much for having me today. My name is Nakia Bryant, and I am your neighborhood estate planning attorney. Something cool about myself? Probably I'm a pharmacist and an attorney, and people call me crazy for that. So I don't know if that's that cool about me, but I think it's pretty cool.
I think it's cool. Sounds like somebody really does enjoy school.
But I promise I'm not going back.
That's what you said. We'll see in 5 years.
Right.
Well, that is really cool, and that's a unique perspective. And we might have before we would start, we might have you back. Today, you're here as the JD. We might have you back on the farm side, looking at psychotropic meds and meds that for those. That's a nice big term. I don't even want to say it that way. Meds that impact our mental health.
Absolutely.
So we really might, because I've been looking for a pharmacist, and I just had that thought. She can come back again and talk about that next year.
I'd love to.
Great. So today we're looking at things like estate planning, which some people don't even know just what is estate planning. You might think, I don't have any money, I don't have an estate. Why do I need to estate plan? So let's start with that. So today, let me just say we're looking at some of those things of getting your affairs in order that we all need to do and that we don't even know how to do. So Nakia is here to talk to us about that. So first, just what is estate planning?
Estate planning is really just what you said, getting your business in order, getting it together. A lot of people are under the misconception that, well, estate plans, that sounds fancy. It sounds a little out of my ballpark and it's just for the rich people, but
Mm.
really it's not. I always laugh and I tell people all the time when they ask me, well, why do I need an estate plan? And I say, do you own a pair of tennis shoes? And they say, yeah. I said, then you have an asset. And I was like, you have that one cousin, the one, and they're going to fight your whole family over that one pair of shoes. And so estate plan is an opportunity for you to plan what you want to happen with all of your lifelong belongings, all of your assets before, you're called home. And so, what we do here at the law office in Nakia Bryant is we teach our clients how to plan out their estates. We help them to build generational wealth and start looking at their legacy. And really thinking about what type of legacy do you want to leave behind for your family. So the estate plan is just that. It's a plan. It's a plan for what happens when I'm gone. Because we know that, it's proven people when someone passes away in the family, some family members just they can't process it. They're grieving, they're not thinking rationally, they don't think logically. And so when you have a plan, you leave your family in a position, in a place for all things good to be already taken care of. They don't have to think about these things. And in some cases, you also help your family avoid having to go through the court systems. I'm a licensed attorney here in Texas. So the laws in Texas may be, same or similar or different from other states. But you leave your family an opportunity to grieve their loss in peace, rather than having the stress of what do we do with this? What do we do with that? Well, we can't do this. We need to do that. And we don't know how to do this. And so all those things and all that stress is really put at bay when you do a very comprehensive and you take the time to plan out what you want to do with your things in the event that, you know what, God has said it's time to come home.
So let me ask you this. So once someone sets up, and we're going to talk about how possibly like a power of attorney, but before I even say that, so once this is in place, it's legally binding. And when you're gone, if you left things XYZ, that's just how they have to go. Can some family member come and say, well, I don't think they meant that.
Well, yeah. So essentially, it is binding. Your will is binding. It's binding on all of your heirs. Your heirs are the family members that you leave behind. Yes, we have cases where I also do probate, where we have family members who will come forth and they're going to contest your will because you didn't leave them anything in your will. And they're like, I know my auntie wanted me to have something, but guess what? Auntie actually didn't really even leave you anything. And so you will have a family member, maybe, come forth and say, hey, I'm contesting the will. Well, there's certain circumstances in which you can contest the will. It's not really valid to contest the will just because you're not happy with what was written in the will. That's not a valid contest to the will, but sometimes people will come forth and they'll say, hey, you know what? My grandmother had a will, but my uncle badgered her into making this will and leaving him everything. And we know that she would have never done that. And so it's called, challenging the validity of the will itself. Was the person who gave the will, which we call a testator or testatrix in the case of a female, did they have capacity when they executed their will? Were they under undue influence when they executed their will? Those are some valid reasons in the state of Texas to contest a will. But I will say it's not an easy feat. So if you are thinking about contesting a will, you got to make sure that you really have a valid legal reason to do so. The other part of that is, you might want to think about contesting a will because if you don't have a very valid reason to do so, Texas allows for what we call an interim clause. And what that means is if you're that family member that wants to make a stink and you want to come forward and make a contest to the will, you are disinherited from the will. And so Texas allows that. If you're the one that says I'm bringing forth a contest, you understand that bringing forth that contest is going to constitute you being disinherited from that person's will. So you got to think it through. You really need to think it through. So those are just some things to think about when you are the family who's left behind and how you want to handle your loved one's estate. Your will designate who what we call an executor will be, and that person is the person who's going to be responsible for carrying out your wishes. Whatever you said in your will, that person is responsible to making sure that that gets done in accordance with your wishes. And so the executor is basically the person in power of the estate that the testator has designated before their death. They've thought this out and they've said, this is the person I trust to do what I have said in accordance with my wishes under my will.
When you say that, I was speaking with someone the other day, and they were concerned about that. They were like, I don't really have anyone in my family that I trust. I trust one person that I would do. It is, and they're only 22. I don't know if I want to put that burden, is how they felt.
Mm-hmm.
But that was the person they felt would do it. But they thought that the person might have undue influence on them to make changes.
Mm-hmm.
Say to that, this is a person who's 22, they're young, but they say I trust this person, but what if others come in? What would you say to that?
So I think part of that comes in education. That's one of the things we pride ourselves with our clients is really educating so the clients really understand what their estate plan says, what everybody's duties and responsibilities are. Generally, executors are given powers under the will, and the will describe what those powers are. And so as long as the person appointed as the executor, if they're, a younger adult, maybe not as haven't had as much life experience, or a mature adult, if they understand what their duty is as an executor, then it makes it a little challenging for anyone to come in and unduly influence them, because the executor is held to a legal standard, and they have a duty to follow what's in the will and carry out their duties and responsibilities in good faith. And so, if the executor understands that, no matter how old they are, then they can really be a good executor over the estate of the deceased person. Um, and with that said, if there's someone that you feel like, hey, I can trust them, but they're so young and I don't want to put this burden on them, there are other alternatives. You can hire a neutral corporation. There are corporations out there that will serve as an executor to your estate. There are some attorneys' offices that will serve as an executor of estate. I don't particularly do that, but especially if it's one of my clients. But there are other alternatives to designating an executor.
Interesting. So you use the term executor. Now, what's a power of attorney? Is that what the executor have? Just what is that?
So the power of attorney is a little bit different. So the executor is the person who's responsible for your estate after you have passed on. A
Mhm.
power of attorney is somebody who acts as an agent on your behalf, that you've authorized to act on your behalf while you're still living.
Mm.
And so, depending on what type of power of attorney you have, you could have a statutory durable power of attorney. Power of attorneys can be drafted to suit the needs of the person. You can have a power of attorney that is indefinite. You can have one that has an expiration date on it. And so, I really encourage people to consult an attorney when you're having these types of documents drafted for yourself. I know people are like, I don't want to pay an attorney because they're too expensive. And no, we're not cheap. And that is true. But depending on your situation and your circumstances and what you're in need of a power of attorney for, you certainly want to have an attorney look at it, because what you don't want is to think that, hey, I needed a power of attorney for this purpose. And then when the need arises, the power of attorney actually doesn't
Mm.
fit the situation. And so I always recommend, consult an attorney. But a power of attorney basically works to give a person that you have said, someone that you trust again, that they have the authority to make decisions for yourself, whether it be financial decisions, decisions around your real property, like your home, selling your home for you, gifting away your personal items. They would have the power in the event that you're not able to make decisions for yourself. I always get clients, when we execute their estate plan, and there's always the option, do you want this power of attorney to be effective immediately or only upon incapacity? And so my recommendation is always make it effective immediately, because you never know when you may need a power of attorney.
Mhm.
Uh, and people will ask, well, if I give them immediate, then they can do whatever they want to do with my stuff. I'm like, no, that's not how that works.
Mm.
Um, it only comes into play if for some reason you cannot make decisions for yourself. So as long as you're still living and breathing, you got all your capacities and you can make decisions for yourself, you make those decisions for yourself. Your power of attorney doesn't step in until a time when you can't.
Mm. Um, so the power of attorney, you talked about the executor. It could be a firm, or it could be an outside entity, or
Mhm,
a person. What
mhm.
about the power of attorney? Is that only a person that you know?
Um,
Or
you
how
can
would that be chosen?
I have not seen anyone do a corporation or other entity as a power of attorney, but not to say that you can't.
Mhm.
But you know, for the purposes of what a power of attorney serves, it would be my recommendation that this be a person who knows you, a
Mhm.
person who respects your wishes, a person that you can trust, because a corporation is not going to know anything personal about you. They're not going to know what you want to do with your stuff. They can only go by what's in a written document, and a power of attorney doesn't dispose of any of your property. It doesn't tell the world what you want to happen with your stuff when you die. It only tells the world, this is the person I've designated to make decisions for me on my behalf if I can't make those decisions. So that's the difference between a will and a power of attorney. Your will is going to tell the world, hey, this is how I want my stuff to be handled in the event that I die. The power of attorney is just, you know what, if something happens to me and I can't make decisions for myself, this is the person that I want to do that for me while I'm still living.
So the power of attorney, the person you choose as power of attorney, and the person you choose as an executor could actually be two different people,
Mhm.
or but they
It
can
could
also
be different people or the same person.
be.
A lot of times clients will designate the same person,
Mhm.
just to keep it easy, keep it simple. They will designate the same person. And it kind of keeps, from having several different people kind of engaged in your personal
Mhm.
things. And again, with the power of attorney, it's the same thing as the executor. Is the person that you designate as your agent has to have an understanding of what their duties and responsibilities are, in being an agent, because um, there are legal responsibilities that those individuals have in being your agent or being your executor. And we call those fiduciary duties. It's a duty that you owe to the person that you are either the executor of their estate or you're the agent as their power of attorney. So you owe them a duty and you've agreed to do and act in good faith.
So it seems like going through an attorney would be a benefit rather
Mhm.
than just doing it online, because now you can probably do everything online,
Yeah,
so that those duties are really explained
correct.
and understood.
Correct. Online, you don't get the personal
Mhm.
consultation with the forms that you get offline. And I'm not
Mhm.
saying, I don't say anything negatively about the
Right.
online forms. It's just when you're handling business that affects your life, I highly recommend that you consult an attorney,
Mhm.
to get your questions answered, and so that you have an understanding of really what you're doing.
So another part of end of life planning or just life planning would be a will. We've talked about a will, and there's a
Mhm.
will and a living will.
Mhm.
Use the term will, and I know about a living will. Can you kind of distinguish those for us?
Yeah, so people get these two things confused. So let me tell you what a living will is and what it is not.
Okay.
A living will is not a will. A living will does not dispose of your property at your death. A living will, what that is like, this is probably the most common way people understand it. If you get sick and you go to the emergency room, they always ask you, do you have an advance directive? And you're like, no, because I don't really know what that is.
Mhm.
Well, an advance directive is a living will. The living will is the decisions that you have made about your medical care while you're still living. You get to tell the doctors, hey, if I'm in a terminal condition, I want you all to do everything you can to keep me alive until you just can't keep me alive anymore. Or, you know what? If I'm in a terminal condition, don't tie me up to machines, don't hook me up to these machines. Let me just die peacefully and let me go on to glory. You get to make those decisions during your lifetime. And that's what a living will is. A living will is a will that is created by you during your lifetime. And you are making the decisions about what you want to happen with you and your medical care while you're still living. And so I like the living wills as a part of our estate plan that we develop for our clients. We include a living will, or a physician's advance directive is another term for it. Um, we include that in our estate plan. We make sure that you have a comprehensive plan. We don't leave you with a piece of it and not all of it. I don't think that's helpful if you don't have all the pieces to your estate plan. And again, you take the bite out of it for your family members,
Mhm.
because it's difficult to stand in a hospital room and see your loved one in their last moments, and you're trying to decide, well, what do we do? They make those decisions for themselves. The living will is, those decisions are already made. And the hospitals and medical providers are going to follow the wishes of that living will if that time arises.
So
So
when you go in and they ask you if you have an advance directive,
mhm.
i.e. living will, and you say yes, you don't normally have a copy with you though.
No,
So
you don't normally have a copy with you, but
work.
again, the education piece, what we educate our clients to understand is that when we create these documents for you and they're executed and they're official, we encourage our clients, share a copy of this with your executor,
Mhm.
your power of attorney, and your physicians. That way, when that time arises, and you're not carrying it around in your pocketbook, nobody does that. No, you don't have it in your wallet. So when that need arises and you get to the hospital and they ask you, do you have an advance directive, you can say yes. And you can also tell the hospital at that time where to find it.
Mhm. Mhm.
You can give them instruction of where to find that document. And so that way, if for some reason you're capacitated when you tell them where to find it, but then all of a sudden you become incapacitated, they can say, well, you know what? Miss Lucas said this was in her safe. And you can find that document in her safe. So we need someone to go get it out of her safe. And so hopefully you've shared your combination to your safe with your executor or somebody that knows how to get into your safe. And then you can recover that document. And so that's something that we also educate our clients on the safekeeping of those documents.
Awesome. Makes a lot of sense. So the living will is really when you're living and proceeding, and a will is after you die.
After
How
you're after you're gone. Yep.
assets and things are distributed.
Correct. So just remember that your will is your last will and testament, it's your last wishes.
Mhm.
It disposes of all of your things after you're gone. And your living will tells the world what you want to happen with you while you're still living. And so it's like they're two different types of wills, if you will.
Okay.
And so I have clients come to me like, yeah, I want to make me a living will. And the first thing I ask them is like, do you know what that is? And so they're like, well, yeah, it's my will. I'm like, no, it's not your will. So, we take a lot of time, we take that time out to really educate our clients to help them understand the differences between those two types of wills.
That's good. That's good. And with the will, so if a person dies, doesn't have a will,
Mhm.
what happens to their estate? And now my understanding of estate, so let's see if I'm right with this, is just what all of your assets and belongings constitute your estate. Am I correct?
That is correct.
So after you die and it's there, your home, your car, your bank accounts, all of this makes up your estate. If you don't have a will, and let's say in the state of Texas, does it automatically go to your spouse or your children, or does it have to go to probate? What happens in the state of Texas?
So in Texas, what I like about Texas is Texas doesn't automatically take your stuff and just send it to the state if you don't have a will. If you die without a will, that's called you died intestate or intestacy. And so Texas has guidelines on how your estate is distributed if you die without a will. So your estate doesn't automatically go 100% to your spouse or to your children. It depends. And I know that's the, favorite legal answer. It depends. But it really does. It depends on whether or not your spouse that you're married to and the children that you have are the only children of that marriage. If you have a blended family, then the estate is split according to guidelines. And so we get this all the time where people do die without a will. And, the spouse thinks, oh, I'm getting everything. Well, your spouse had children before your marriage. So everything doesn't go to the spouse. And so the spouse gets their portion. In Texas is what we call a community property state. So what's mine is yours, what's yours is mine. And so the spouse would get their community property share. They're entitled to that. But the share that goes to their deceased spouse, that portion gets split. And it gets split between the spouse and all of the children of the marriage and not of the marriage. And so then when you have a person who dies without a will, who is not married at the time of their death, then their things get distributed a little bit differently. If they have children, then it may be split equally among the children. If they don't have children, it may go to their parents. It may go to their siblings. So this is something that we, again, take the time to educate our clients on, because people have the misconception, that, oh, I'm supposed to get everything. And we get clients that come to us for probate of a deceased person who didn't have a will. And, it's hard sometimes to explain to the client that you're not the one that's going to get it. You're not going to get all of it like you think. And so it's helping, in that case, it's really helping the family understand how Texas looks at it. The one thing I think is beautiful about Texas is Texas tries to make sure that they will reach as far down your bloodline as they can to find somebody to take your stuff.
Okay.
And so that I think is beautiful about Texas, because some other states, they're like, we don't see anybody, we're going to give it to the state.
Okay. Mm-hmm.
And so, and this is why it's really important to have an estate plan, because it takes all of this out. And there are some ways, and we're happy to talk to people about it. There are some ways to avoid the probate process. With your estate. There's ways to keep your estate private. And so we talk to our clients about that when we're in the estate planning process as well. So Texas has, it has guidelines that are set. And so we see this a lot with people who die without a will and they have property. Well, they never transfer their property. So now there's a fight on the family members about the property. Or we see things where someone's been living in a property for years and the family member, no one has ever thought anything of it. And then all of a sudden you have one family member who's like, no, I'm supposed to have a share in that house. Well, you know what? Your great-great-grandmother never transferred the property to your grandmother, and then your grandmother never transferred it to her kids or someone else. And so now we have 3 or 4 generations of people who have died and the property was never transferred. So now we got to go back and try to fix the title to the property. So probate can get very, very involved. And so this is why we really encourage people, and we're taking a stand to educate people on why it's important to have an estate plan, because you avoid all of these problems when you have a plan. And so everyone should have a plan. It doesn't matter the size of your estate, whether you have $5 in your estate or you have $5 million in your estate, you should have some type of plan in place. And it really is not so much about the asset, but the family.
Got it. That is, it's amazing. You've given us a lot of information that I think is beneficial. And, the show is called Black Mental Health is Black Health. How does this impact our mental health? If you have ever been in the situation where the end of life and afterlife things were not planned, it definitely can impact your mental well-being.
Absolutely.
So thank you so much for sharing this information with us. I think it's very important. If people want to contact you, how can they do that?
They can visit us on our website at www.nwblawfirm.com. And they can schedule a consultation with us, and we're happy to talk to them and get them planning out their estate. Or they can call our office directly at 682-240-6484. And if they mention that they saw us on Black Health is Black Mental Health is Black Health podcast, then we will actually offer them a free consultation, because we don't do those for free. We will actually offer them a free consultation as an audience member, and hopefully help them get their estate plan, get their business in order.
Awesome. And I also want to share that this weekend, Saturday, December 7th, from 10 to noon, I'm doing a workshop titled Managing Holiday Emotions. It's not the most wonderful time of year for me. For this time of year, for some people, it's not good. So you can click the link below to register, and when you register, payment information will be sent to you. And once again, thank you, Nakia Bryant. You've given us a lot to think about.
Thank you, Miss B, for inviting me, and I look forward to coming back and talking to you.
Yes. Bye-bye.
Bye-bye.